I'm sure have questions to put to you, but I'd like, if I may, to begin by inviting you to make any opening comments. We, of course, have seen the speech that you gave to RUSI, which was a very helpful way of informing us of your opinions and your thoughts on this important question. If you would care to make any opening comments, please feel free to do so.
Well, thank you very much, and thank you very much for inviting me to come to be with you this afternoon in the context of your inquiry on a vitally important issue, security and privacy, and how we strike the right balance, not least in view of the enormous technological changes going around us. I would really make three, I think, opening observations, which I hope would be of some help. I mean, firstly, I sometimes feel that quite a lot of the debate in this area becomes unhelpfully polarised, as if any additional measure to enhance collective security will always come at the cost of individual privacy, and any step to enhance individual privacy will always come at the cost of collective security. I think that's self-evidently not the case. I think the relationship between the two is altogether more complex. You can't have privacy unless you have the security, if you like, to enjoy the freedoms that we do in a free and open society. And equally, you don't create security in an environment in which citizens feel that their privacy is not safeguarded. So I've never quite believed that there is this zero-sum game, this seesaw effect in the debate. I think the tension is more interesting than that, and in many ways we can seek to do both enhance security but also protect privacy. It isn't always a crude trade-off. That's the first point I'd make. Secondly, as a sort of, how can I put it, sort of old-fashioned liberal, I always think that the state in this area should always be a reluctant intruder. The ability of the state to intrude in someone's privacy in the name of collective security and so on is an uncontested role for the state, but it's one which must always be applied on the basic tests of necessity and proportionality and held to proper account, subject to the right levels of transparency. And again, I think if we keep that sort of prism in mind, it's the most helpful way to deal with these issues, because often it's not the case whether the state has the right to seek to gather or analyse this or that information. It's whether it's done in a way that is properly proportionate and bound by the tests of necessity and held to proper account. And that, I think, not least as the sheer volume of information that is involved has grown exponentially, certainly since we last legislated in this area through the RIPA Act 14 years ago. But the sheer multiplicity of the threats, I think those are the tests and the concerns that are always uppermost, at least in my mind. And then the final thing is, I have a sort of feeling, and I'm sure we'll come on to this, that because the level of technological innovation is so great, and the volume of data is now so huge. I read somewhere the other day that the amount of emails sent in this country in 4 days is more than all the mail that is sent, during the whole year. It's 1.3 trillion. I mean, something. It is of such unimaginably large volumes, and we didn't confront that well when we last debated it in Parliament and when we last tried to sort of set the legislative framework for this. And I just intuitively think that the scale of the information involved, the velocity of the technological change involved as well, means that a lot of old distinctions are increasingly being blurred or possibly destroyed altogether. National and international is increasingly a meaningless distinction. Domestic and international IT traffic is becoming synonymous with each other. The distinction between communications data, or what some people call metadata, and content is increasingly blurred compared to the debates we once had about this. And for those reasons, I increasingly question our ability to deal with some of these issues on our own. In other words, I think we will have to move in time towards a more sort of treaty-based approach, in which jurisdictions become more compatible with each other across the world, because this is a global phenomenon which needs some sort of basic global disciplines and checks and balances, including perhaps it's rather a pious way of putting it, in the long run, a kind of a constitution for the internet, if you like, a sort of sense that people who use the internet feel that they've got certain, there are certain parameters and certain rights which they can exercise in that space. So those are my first three fairly esoteric thoughts, but ones which I hope are nonetheless helpful.
Well, thank you very much for that very, very helpful introduction. Can I perhaps just lead with a particular question to you? Since the turn of the century, we've had really two developments coincidentally in parallel. We've had the very serious growth in the terrorist threat to the security of people in this country. We've had 7/7 bombings, but also many other plots, some of which were disrupted by the intelligence agencies themselves. But parallel to that, we've had what you've just remarked upon, this extraordinary technological revolution, which has made so many more things possible from a technical point of view to our intelligence agencies as they try to deal with this threat. Do you start from an assumption that, obviously under law and with proper safeguards, the intelligence agencies should be able to use all the technological potential that exists to try to identify terrorists and potential threats, particularly as, of course, the terrorists themselves can sometimes be very sophisticated in their use of that very same technology?
Yes, I think is the short answer. You have to compete in the same space where the threat presents itself, and you've got to give the agencies the means to compete in that space, if I can put it like that. Where it becomes more complicated is where you try and draw the distinction between, if you like, going after individuals and seeking to somehow, I mean, this is this whole debate about bulk data versus sort of warranted investigation, needle and haystack, and so on. That's where it becomes a lot more complicated. Because
where do you come down on that?
Oh well,
in that debate.
I mean, from a pragmatic level, it seems to me you can't find the needle unless you have a haystack. But when we last legislated on this, which is why I think RIPA, while it serves us well, it's right to sort of ask questions about it. We didn't at that time as a country legislate for the kind of haystack we're having to create. And then there's the whole question: how long do you keep that haystack? This idea of inert data. Some people, that's one sort of, if you like, extreme of the debate, say just holding that inert data is already an invasive act of privacy, because you are just holding, even if you're not doing anything, even if you're not scrutinising it. Other people say no, it's an entirely innocent activity. It's like a sort of like a great tub of, I'm mixing my metaphors here. It's a great sort of tub of data. You're not doing anything with it, and you then only on a warranted basis go after something inside it. My own view is that just by virtue of necessity, you do need to create that receptacle of unexamined data, which you then have to scrutinise. But it is not enough for the state simply to sort of assert its right to do that. It must prove it, and it is perfectly legitimate for us to now ask questions about how long you hold that data. How can we be absolutely sure that it can't be put to more malign use, because it is data which is available, and you could imagine circumstances in which people were to get hold of it in a way which is not as benign as is clearly the case. And by the way, I should say on that, having obviously worked the last 4.5 years in government as Deputy Prime Minister and seen the work of the agencies, including and most especially GCHQ in this area, I have absolutely no doubt at all that the people in the agencies work punctiliously and with great attention to their sort of legal duties. I've never for one moment questioned their commitment to their legal duties. It's not really, the onus is not on them to answer those questions. Actually, the onus is on us to ask ourselves whether the regulatory and legislative context in which we place them has kept up with events.
Thank you. Hazel.
Yeah, just to press you a little bit more on this area, because we've had some fascinating submissions from a whole range of, particularly, I suppose, civil liberties groups, from Big Brother Watch and Liberty and Amnesty, a whole range of groups. And we pressed them quite hard to say that on bulk collection, if it could be shown that by properly interrogating bulk collection, we were able to identify targets that then meant that we could prevent plots, would they still regard bulk collection as an unacceptable infringement of people's privacy, because that's their starting point. We pressed them really hard that even if there was evidence that this stopped plots and saved lives, would they still then regard that as unacceptable? And virtually all of those groups have said yes, they would.
Would what?
They would regard bulk collection in and of itself as such an infringement on people's own privacy that it would not be justified. And you're now telling us that you take a different view in relation to bulk collection. You do regard it as justified.
Well, unless someone else can show me how we can go after the data which we're perfectly entitled to as a state in order to keep people safe. In other words, how do you... Well, I'm just reworking the familiar analogy. How do you create the haystack without which you can't go after the needle? But where... So it's not really so much for me an issue about whether that is just an unavoidable reality of how information is contained and framed at the moment. It's more, have we anticipated that in the regulatory and legislative framework in which that data is collected? And there are a number of distinctions I intimated earlier which aren't actually explicitly dealt with by RIPA. So the distinction between bulk data and content is not, it's alluded to, and of course what GCHQ does is entirely lawful, and I think in the terms of 884 warrants it's explicitly alluded to, but slightly in passing. You've got this whole increasingly fungible distinction between communications data, the kind of how you categorize data, and the content of data. Increasingly a lot of experts, I'm sure they would have repeated this to you, tell us that actually it's the comms data that tells you as much as you need to know than content. And yet it's put on, and yet the hurdles by which the state justifies going after communications data versus content is much lower, as set out in RIPA. Is that appropriate to the way in which comms data in many ways has increased in its utility to us? The distinction between external and internal. You and I could send an email to each other and it could be routed via a completely different hemisphere. Is that external communications or is it domestic? Can GCHQ's external facing mandate, unwittingly perhaps, actually end up covering what are, strictly speaking, domestic forms of communication? All of those things seem to me to have arisen as dilemmas since we last legislated on it. That's the point I
think there's much common ground there on all of those issues that you've mentioned, but one of the sticking points was, for many of the people who've given evidence, that the actual act of bulk collection of data and content was actually an infringement of people's privacy. Even though they didn't know, that information was never interrogated unless it was specifically targeted. The very act of collection was unacceptable. And you're telling us, and you've been very clear about that, that you do not subscribe to that view. No,
absolutely. Let me be very clear. I have not yet seen a way in which we can ask our agencies to go after data which they should do in order to keep us safe, without in some way doing so by first setting aside the kind of the kind of granite block of data in which they then interrogate the much more specific data thereafter. However, the point I am seeking to make is there are very, very legitimate questions about how long you hold that sort of inert data, how it's held accountable, how it's scrutinised, how it's checked, how do you ensure that it's not in any way falls into the hands of people who might want to make use of it in a way that converts it from being sort of inert data into being actively scrutinised. This external domestic distinction comes to play as well. And all of those things, it seems to me, need to be revisited, and indeed are being revisited by your inquiry and those inquiries held by others.
Thank you. Julian Lewis.
Yes, going straight on from that, what you said today is entirely consistent with what you said to the RUSI when you said the idea that the security services should be able to track communications in order to pursue or disrupt serious criminals and terrorists is not controversial if, in order to do that effectively, the judgment is that there is no practical alternative to bulk data collection, then to some degree we should allow it.
Correct.
And that's what you said today. Now, just playing devil's advocate for the moment on the basis of the arguments that we've heard against that, points have been made about, first of all, whether or not there's an opportunity cost in the respect that the effort that's put into collecting bulk data detracts from the effort that might be made with the same resources to go after more targeted surveillance. And secondly, of course, people do say that they don't have the evidence that the collection of bulk data has in fact resulted in the creation of many or any new leads that have prevented terrorist attacks. Are you able to comment on both of those 2 points?
Well, on the first, I would say, of course, the use of bulk data is not the only means by which the agencies can identify data which is essential to keeping us safe and identifying threats which need to be countered. Of course, there are a multitude of other ways. Human intelligence, other forms of leads where you can go straight, if you like, to the person, exactly. or their technology or the premises, and a lot of that, of course, is set out in the warranted powers provided to Secretaries of State under RIPA. So it's not the only means. It is, however, in my view and my experience in government, it is one legitimate means, and I'm absolutely persuaded from what I've seen that there are circumstances in which it would have been impossible for agencies to interrogate specific data about specific threats without, in a sense, first having cordoned off the data in which it is sort of situated, if I can put it like that. I am persuaded of that. To only repeat what I just said earlier, where I think there is a legitimate space for critics to say, well, have we really got the kind of framework right, is, as I say, is the retention, the scrutiny, the accountability, the reporting of it all, is that as strong as it can be. My view is we could go much further, and we've taken a number of steps, but we could take more steps to.
So you think that the oversight bodies, including this committee, could do more to satisfy the public that these techniques are necessary in terms of the results that we can be told they've obtained?
If I can just step back just for a second, because I do think it's relevant. Look, we live in a sort of period of our history where, this is a commonplace observation, where all forms of authority are treated with unbridled scepticism and cynicism. And that may be, whether you're a doctor, a priest, a judge, or most especially perhaps a politician, quite rightly there is a very, very forthright sense of scepticism about how authority is wielded, particularly when it's wielded in the name of the public. I desperately want to avoid a situation where the agencies are constantly having to fight just for their basic legitimacy. And I've never ever seen, for instance, increasing oversight or increasing transparency as an enemy of the work of the agencies. I actually think it's an increasingly indispensable part of ensuring that public confidence in their work continues. My personal experience is there's a bit of a tendency to keep stuff secret which could easily be published without any harm to. That's my view. I think we could unclench quite a lot when it comes to some of the data that could be. A good example is we know there are about 500,000 communications data requests made every year. There's no data, there's no information in the public domain about, is that 500,000 individuals, is that 500,000 premises? It might actually be a much smaller number of individuals, but lots of repeat communications data requests. I think the public is perfectly entitled to know that, and that's one of the things I hope will be published in the transparency report, the first of which I hope will be published before the election, that we agreed to as part of the measures around the rather unfortunately named DRIPA Act, DRIPA legislation. So I think we can be more open. I think the improved powers of this committee are an important component of that. As you know in the speech, my own view is that this committee could be reformed and strengthened further through various means. And I don't see any of those improvements as a threat to the legitimacy of the agency. I'd actually flip it right round and say if you don't do it, you create the conditions in which public scepticism about what the agencies do only festers further. Thank you.
Robin Butler?
Just considering the bulk data thing, which is going to be very central to us, as Julian has said, I mean, one of the objections is a utilitarian objection, you know, that there's no evidence that this actually is effective in producing new leads. But the other objection, the objection of principle, is best illustrated by the issue about holding DNA universally. And people say, you know, that the courts have found against holding DNA, even though you don't interrogate it unless there's some reason to interrogate it. How do you distinguish between those two cases?
Well, difficult, isn't it? I mean, ID cards is a similar example. One of the first acts of this coalition government was to scrap the ID card database that had been established by the previous government on the basis that we felt that the utility, and there's undoubtedly a utilitarian case for coalescing a lot of information about one person on one sort of identity chip, if you like, was outweighed by the concerns about privacy and the possible abuse of the kind of honeypot of data that you create about individuals. And so we physically destroyed the database, and we certainly had the public on the side. On the side. And look, I'm not pretending that people's reactions to these things are meticulously consistent, because one thing which has been regularly observed, and I think is self-evidently the case, is that people appear to be more relaxed about data that they provide to private sector players and operators, your supermarkets, your retailers and so on, than to the state. I think that speaks rather well of the British people. They're just a lot more sceptical about what the state's doing and what their supermarket's doing. And they're, in a sense, right, because the state has ultimately more untrammeled powers to invade the privacy of an individual under certain circumstances than your local supermarket does. But there is not complete neatness in these things. I am persuaded, but I admit I question whether I would be quite as persuaded as I am if I had not had the experience of being in government for the last 4.5 years and seeing the utility of what the agencies do, and, as I said before, the seriousness and meticulousness within which they take their legal duties, the way that they're conscious of their Article 8 ECHR obligations, namely that there is a right to privacy under Article 8, but it's not an unqualified one. And my experience is that they try to balance these things. I have come to the view that it is difficult to argue that it is possible for those agencies to do what any reasonable person expects them to do in the kind of data-rich environment which they now have to operate, without, to some extent, but I stress to some extent, holding inert data which is then interrogated more precisely. If there was a way to square the circle, I know would be more delighted than me. If everything could be done through a sort of individual warranted process, then great. It's just not how data presents itself right now.
May I go on to the Communications Data Bill, please? The earlier version of the Communications Data Bill you couldn't accept, and it didn't go ahead. We're told there is a new draft of a Communications Data Bill. I don't know whether this is a Conservative Party construct or it's a government construct. Can you tell us, and can you tell us whether there is a new draft to which you have less objection?
So, no, there's not a new there's no recycling of the Communications Data Bill in existence, certainly not one that's sort of been circulated in government for collective discussion. The Communications Data Bill sought to, in effect, do three things. One, oblige companies, the internet service providers, to retain for a year all the weblog activity, the history, up to the, as they put it, up to the first slash of any website that you or any of us have visited during a whole year. Secondly, to resolve this technical issue that the IP addresses are not individually matched to mobile devices anymore. In effect, one IP address is being used for multiple mobile devices at the moment. That's proving very difficult for law enforcement agencies. And thirdly, to make clear that there is an extraterritorial component to the requests made by the British state and its agencies of the internet service providers, where we're fulfilling our duty to keep British citizens safe. Now, I have always said, and I said publicly at the time, I've got no problem at all with the second part of that. I think there's just an obvious technical issue. where it is proving to be very difficult, and there were some notorious cases involving threats to the lives of and the welfare of some children, which have recently been a subject for some public discussion, handled by the National Crime Agency, where it's very clear to me, having looked at it, that the specific problem, according to the National Crime Agency, was they couldn't match the IP addresses to the device, and that's why they couldn't pursue the leads they had. I think we have to deal with that. And I want us to deal with that, and I hope we'll be able to present to Parliament shortly a legislative change which would deal with that problem. The third of these three issues, extraterritoriality, is a little bit more complicated, but has been partially addressed by the DRIPA legislation, where we've made it clear that when requests are made for data from internet service providers, the acid test is not where they are located, but whether the data that we want pertains to British citizens, either threatening our safety here in Britain or to British citizens who are under threat themselves. And that's the change in the law that we clarified in the legislation just before the summer recess. It was the first bit that I objected to so strongly, and still do now, because I don't think it meets some of the tests that I've talked about earlier. I don't think the necessity or the proportionality was demonstrated by that at all. I think storing the weblog record of every single individual in this country for a whole year was a disproportionate response to the challenge it was seeking to address. So, sorry to give you a rather lengthy reply, but there's a slightly sort of crude thing, you're going to do the communications data bill or not. I've always said, actually, we should do 1/3 of it, and I've actually been one of the leading proponents of it, and have recently expressed my slight frustration that we haven't moved as fast on that as we should, given that my personal insistence, it was included in the last Queen's speech. We've addressed in part the extraterritorial component, where there was an increasing risk of legal friction between internet service providers located elsewhere, whose servers are elsewhere, and our legitimate wish to nonetheless extract or demand data from them. It was the first bit of that sort of tripod of measures which I felt was disproportionate, and I haven't wavered in my view on that at all.
Thank you. Michael Ledden.
You raised some very important questions, I think, about bulk data, both in your speech to Rusi and also, I think, today. I just want to press you a little bit, because you were talking about the extent of bulk data collection, talking about the length of the time it was held for, and the criteria on which it should be justified. Now, I wonder whether, first of all, you could give us some indication of whether you see a general principle emerging which deals with all three of those, or whether it might vary from circumstance to circumstance according to what might be the perceived level of the threat being pursued, or whether alternatively you saw them being set out in terms of particular lengths of time, and whether you have any view on that. I mean, how much data could be collected, how long should it be held for, what should be the criteria?
I do not have a ready-made answer to that at all, and in fact, I think one of the interesting things is I haven't come across anybody who's got a sort of oven-baked solution to this. Everybody is still grappling with this same dilemma, and I actually trying to look, as I try and compare the debate here to the United States, to the France, to elsewhere, I actually think the level of debate in this country is already actually a lot more sophisticated than it is in other jurisdictions. No other jurisdiction has come up with a neat answer for this either. But I think this inquiry, the Rusi inquiry, the review by David Anderson of the RIPA legislation, the commitment that we've made, given that the DRIPA legislation is on a short sell-by date, lapses basically at the end of 2016, if I'm right in remembering, means that we're on a sort of self-imposed race against the clock to come up with an answer like this, and I hope we'll be able to use the time between now and the general election through these kind of inquiries to try and coalesce around a sensible approach. But no, I'm not going to pretend for a minute. I can articulate the question well. I can't pretend to. I can articulate the answer well at the moment.
Can I touch on one other area? Because I've got a great deal of sympathy with what you said about the distinction between external and internal data transactions. And they are getting very fuzzy at the edges and quite difficult sometimes to distinguish. But do you accept there are reasons to have a distinction? Let me give you one example, because the threshold for external data intercept is much lower than for internal. If we are looking, for instance, which I presume we are, at what is happening in Yemen, which is, as we know, a potential source of a threat to this country. Is there not a justification for saying that there should be a lower threshold there, that is an external, clear external, and that we should be allowed, therefore, to use the same distinctions as exist at the moment?
Yes, to be very precise, on that basis, I have no problem with the distinction, that there is a different kind of hurdle, if you like, set for the central mandate of GCHQ to help us garner information from elsewhere in the world to keep ourselves safe from external threats. My concern is a slightly different one, is that there is a risk that those lower hurdles, if you like, are actually applied to interactions and exchanges which, while they might be routed via servers which are located abroad, actually involve what, to all intents and purposes, is domestic communication. And I cannot stress enough, I don't think this is willfully happening. I don't think there's any deliberate attempt to do it like that, but there is a clear risk, given how almost interchangeable now domestic communication and the external or international routing of those communications has become, that we could actually unwittingly be applying a lower, for want of a better word, burden of proof to what are nonetheless actually domestic communications. And that was never the intention of the legislation. But clearly there's a technological risk now that is what might occur. And that would make me feel uncomfortable, because the distinction you allude to was precisely because it was felt that the government of the day, that the state, should have to jump over much higher hurdles when it's scrutinising legislation about fellow British citizens. And I don't want to see a lower burden of proof being applied to communications between British citizens because of the technological fusion of domestic and external forms of communication.
George Howard?
I just want to see if you can give us a view on the warrant system, intercept warrants. At the moment, the responsibility lies with the Secretary of State, or a Secretary of State. We've heard a number of people who've given evidence who've argued that should be a judicial function rather than a ministerial function. Do you have a view on that?
My knee-jerk response is that having a judge doing that makes sense in jurisdictions where you have sort of a tradition of judge-led inquiries and where judges play quite a different role, candidly, than it does in our system, where you have just a different division of labour between executive, legislature, and judiciary. So I'm not persuaded that, if you like, implanting the role, a more sort of activist role, if you like, in terms of the conduct of inquiries by judges, which might make sense in other jurisdictions into ours, is necessarily right, as long as, well, especially as long as the decisions taken by the politicians involved are properly scrutinised and held to account. And that's again where, and again, I know you'll be familiar with this, there's real frustration on my part that actually, if you actually read the scrutiny applied by the two commissioners, it's of a very high quality. It's of a very high and exacting quality, but no one knows about it. No one has any idea about the sort of checks and balances which are applied by way of these two commissioners. And again, I think we need to try and think more creatively about how we can bring that more into the open. There have been significant steps to do so recently, but we need to do more of that.
Do you think that is a problem of process, resources, or is it about the culture of the judiciary that don't worry too much about transparency? It's a question of making the right decision, and you don't have to defend it. You've made the right decision.
I think there is a bit of a resource issue, in my personal opinion. But again, that can be addressed. But I strongly agree with you. There's a bit of a sort of culture there that because these figures, and they're very distinguished figures, are all drawn from the senior judiciary, do their work, they do it meticulously, they do it forensically, produce a report, it goes to the Prime Minister, in a sense, from their point of view, job done. My concern, for the reasons I alluded to earlier, where we're trying to kind of almost re-establish or at least reinforce public legitimacy and acceptance of what the state does in secret on our behalf, you can only do that if those forms of accountability are much more transparent and much more open and much more comprehensible to the lay observer. They're not. It's far too circular discussion at the moment between sort of experts in terms which normal people don't understand.
Not outward facing enough.
Yeah.
Thank you. Ming Campbell.
Isn't the position about the commissioners really not so much about them, but the remit which they've been given? If their remit was changed in some of the ways you've described, then they would have to fulfill that remit. And if we think back to the Binyam Mohammed case, which of course went in open court, there certainly was no reluctance on the point of the Master of the Rolls, for example, to express himself in as strong terms as he thought appropriate. So maybe it is more a question of process than substance. But if you accept the job, and you accept the remit, then you have to fulfill that remit, and maybe changing the remit would be enough to meet the problem.
Yes, and dare I say it, not least to you, but maybe the candidates who fulfil these important functions don't necessarily need to be limited to senior members of the judiciary. I just posed the question, maybe opening it up to a wider field of possible candidates. The only other point I would make was that, and we will legislate on this shortly, and then establish it before the election as part of the flanking measures around the DRIPA legislation. We, as a government, announced that this was done at my initiative, that we would emulate the American model by creating a privacy and civil liberties board, which builds on the role that David Anderson has. That's obviously different to the commissioners, but nonetheless important in the whole kind of wider architecture by which people are held to account and these decisions are scrutinised, so that you have a more established and public forum by which privacy and civil liberties concerns are tested and examined and pronounced upon when new policies are developed. And I think that again will be a helpful new innovation, because it'll bring out into the open quite a lot of the kind of balancing discussions which are at the heart of this committee's inquiry, but also often, of course, at the heart of a lot of the discussions within Whitehall. And again, I hope that will bring out that iterative process, security versus liberty, or trying to balance the two in a more open and grown-up fashion when new policies are developed in the future.
Fiona McTaggart. I'm sorry, Ming.
Could that board fulfil the function of, as it were, pre-legislative scrutiny?
Well, we're working on the details as it happens, but the inspiration of it is, as I say, derived from practice in Washington, where policy ideas can be scrutinised at an early stage for their effect on privacy and their effect on civil liberties, because, as I'm sure the committee would appreciate more than most, institutionally within Whitehall, you've got quite rightly a strong departmental representation for this kind of security interest. You don't have an institutionalised counterbalance which says, well, hang on a minute, there are also privacy and civil liberties considerations, and that's what I hope the creation of the Privacy and Civil Liberties Board will do. It will just institutionalise a kind of balance in the debate at the earliest possible stage as policy is fomented and shaped.
Thank you.
Fiona?
I imagine that many Liberals would find it surprising that you are content that the government can hold bulk data accessed in this way. But you've been very clear about that. One of the things that you haven't been so clear about in your speech to Rusi is whether metadata should be treated as less sensitive than content. You raised that as a question, but it was one that you didn't answer. Could you perhaps answer?
I don't have a neat answer. It's slightly like many of these dilemmas. All I point out is that what you can do these days, I mean, there's a bit of a semantic debate about what metadata really means, but let's assume that for the purpose of this discussion, we use metadata and comms data interchangeably. In other words, how you categorise data rather than the content of it. The the sort of when and how long of a telephone call rather than the content of it and so on. If assuming that's what we mean by communications data, by metadata, I am told that it is increasingly possible to use metadata to provide as rich a picture about what someone is up to, what they're doing, what their intentions are, than content. And so in exactly the same way that we've just had a discussion about whether the fact that there is a discrepancy in the hurdles that are set for the scrutiny of data which is held or exchanged abroad compared to that which is held or exchanged domestically, I also think there's a question mark about whether the fact that we have discrepancy on the hurdles that need to be met to deal with communications data compared to content, which is the founding distinction at the heart of RIPA, which is why David Anderson's review and this inquiry is so important, because that legislation a decade and a half ago was based on a very, very firm view that these were completely different, they had completely different uses, that the use to which you could put metadata compared to content was quite different. That is clearly no longer quite the case as it was, and I think therefore it raises a legitimate question about whether we should be applying the same or adjusted hurdles. On the first point, I don't actually accept at all for a minute, and I say this as a fervent, lifelong liberal, I don't believe for a minute. A liberal is no slouch in saying that in certain circumstances the state, sort of according to the principles of J.S. Mill, has the right to interfere with the liberties of an individual if it's doing so, to protect society. But it needs to be done proportionally. It needs to be done in a way which is accountable, which is done transparently. Liberalism.
Bulk data is proportional.
Well, that's the question. Is it? What I've said earlier is I'm persuaded that it is not possible to ask the agencies to do the job we've always asked them to do, which has not been a subject of debate or contention, that there is a role for agencies to do things in secret, to interrogate information on our behalf in secret to keep us safe. I'm not at the moment, because no one has demonstrated to me that it is possible for them to do so in this new data-rich environment we work in, without, in some shape or form, holding data inert for a temporary period of time before scrutinising an individual component within it. If technologically there's a fix for that, great. So far, I've not seen one, and where I share some sympathy with the kind of more purist critics is that the ability for the state to do so needs to be proved, not just asserted, and there's a legitimate debate about whether you hem it in with new requirements, caveats, time limit, and all that kind of stuff. But equally, I don't go with them as far as somehow claiming that it is an a priori sort of abuse of the power of the state to do so in the first place.
Thank you. Mark Field?
Just very briefly, picking up on one or two of the points that have already been made. I accept, and I agree with you, the zeitgeist is for transparency, for accountability. However, dare I say it, that level of transparency in many areas of public life has not enhanced the reputation. Probably the only exception might be the monarchy, and even then might argue that the move to transparency there in the 70s and 80s didn't do any great favours, but nonetheless it's restored itself. I do wonder whether just having a push towards transparency towards our intelligence services necessarily would be the right way forward. I think there is actually a very grown-up and intelligent mentality from the British public, perhaps in contrast with many other demos, whether it's in bits of Europe or in the US, that says, actually, we accept an element of their work has to be in secret, and that's the right way forward, and we expect them to look after us, and the quid pro quo is they get on and do it quietly outside the public glare. And therefore I do wonder, whilst I don't disagree, that there needs to be a move towards some of the transparency that the public life in the modern age demands. Do you feel that there might be some mileage in actually having, rather than a lot of piecemeal bits of legislation going forward, having a big consolidating piece of legislation that will allow essentially the political class also to make the case to the public to say the importance of the work that is done. But by bringing a lot of these strands together rather than playing catch-up, whether it's updating RIPA, looking at communications data as a whole, going through a whole process of emergency-type bits of legislation, but actually having a really good look at this and being able to level with the public about what is required in the modern world.
Well, the first point I made, of course I agree with you that transparency in and of itself doesn't magically create legitimacy. I think I see this in a much more multifaceted way. So there is transparency, publication of information. There is the balancing, as I said earlier, institutionally, in a more sophisticated way than is currently the case within government, between the considerations of security and the considerations of privacy and civil liberties, which is why I attach real significance to the establishment in the coming months of this new Privacy and Civil Liberties Board. There is how oversight is exercised by committees such as this. There is the role of the existing forms of scrutiny by the commissioners. Is that comprehensible enough? Is it communicated enough? And then there's the issue of whether the sort of founding legislative framework makes sense given vast technological changes. Now, I think we're condemned to have this great debate all over again in the early stages of the next Parliament. I mean, we very deliberately created a bit of a ticking time bomb by saying, well, we'll legislate for this, but it'll lapse, come hell or high water, by the end of 2016. So the next government and the next Parliament will have to revisit all of this. And in many ways, I think the inquiry that this committee is conducting and the work that Rusi is conducting and the review that David Anderson, they all feed into what will have to be a major debate in the early stages of the next Parliament. And my hope is, the experience is not that encouraging in this regard, but my hope is that we could seek on this issue, if not most others, to try and create some kind of cross-party consensus on the back of the recommendations of this inquiry, external bodies like Rusi, the work from David Anderson and others, because that would be desirable to try and resettle this debate. Now, would those people who feel that for the sake of argument the agency should be, I'm exaggerating for effect here, should be able to do exactly what they like and should never have to explain anything to anybody? Well, of course they won't like the move to greater accountability and balance and so on. So would those people who think that the holding of any data by the agencies under any circumstances is a sin, would they be satisfied? No, of course not. But hopefully we could start trying to corral this debate in a more informed way towards a kind of centre of gravity which strikes the right balance, and which is liberal, small l liberal, I stress, small l liberal in the way in which that very considerable power and the very considerable deployment of secret authority is held to account and is deployed proportionately, but nonetheless recognises that the agencies have to continue to deploy those powers, particularly in this day and age, to keep us safe. Because, again, one thing totally familiar to everybody around this committee, but one thing that I've learned in spades over the last 4.5 years in government is that how we think of conflict, how we think of warfare is becoming increasingly an online phenomenon. It really is. The days when it was all about tanks and battleships are long gone. We're dealing with stateless groups. We see it in ISIL who operate in a very sophisticated way online. And that, it seems to me, that is a harbinger of the future.
Thank you very much indeed. That brings our evidence session to a very good conclusion. I'd like to thank you on behalf of the committee for being so frank, so very comprehensive in your comments. That has given real value to the work we are doing. Thank you very much.
Thank you. Thank you very much.
Order.
Portcullis House, the Boothroyd Room. Portcullis House, the Boothroyd Room.